Hello everyone. I hope you have watched the previous two videos, which was for partnership unit 1 and unit 2. Today we are going to discuss about unit 3 of partnership, which is about registration and dissolution. So let's start with it. Registration of partnership firm. Is registration of partnership firm mandatory? No, it's not mandatory. So when law says it is not mandatory, okay, when law says it is not mandatory, do you think there would be a punishment for not registering your firm? Obviously not. Because when it is not mandatory, how can you put punishment for that? So it is not mandatory to register the firm. And when I say it's not mandatory, that means there is no punishment if you don't register your firm. So there is no punishment for non registration. Registration is optional, but it is desirable. Why? Why is it desirable? Because an unregistered firm faces many disabilities. So let's discuss the disabilities of an unregistered firm. First, it cannot sue a third party. So if the firm is unregistered, it cannot sue a third party. But can the third party sue the firm? Yes. Third party can sue the firm, but the firm cannot sue a third party. Second, it cannot claim a set off of more than rupees 100. What is set off? We both owe money to each other. And the firm is trying to claim a set off. The lower amount is set off. So because the firm is unregistered, what is the maximum amount that they can claim for set off? They cannot claim for set off of more than rupees. They cannot claim a set off of more than rupees 100. So the maximum claim for set off is rupees 100, and the partners cannot sue each other. So if the partners also want to sue each other, I have rights given by the act, I have rights given by the agreement. If I don't get my rights, I cannot sue the other partners if the firm is unregistered. But yes, if I want to dissolve the firm, then even if the firm is unregistered, I can sue. So I can sue for the dissolution of the firm or for the accounts of the firm. Other than these two, I cannot even sue, the partners cannot sue each other. Now, many a times they ask this one question: what are not the disability of an unregistered firm? And what people do is they write the disability. Please don't do that. What is not a disability? The third party can sue the firm. What is not a disability? They can claim a set off of up to rupees 100. What is not a disability? For dissolution of the firm, the partners can sue each other. So please don't write what is a disability, right? The question is what is not. From the disability, you are getting the answer. So make sure you write the correct way of answering. Okay. If a partnership firm wants to sue a third party, what are the two conditions? First, the firm should be registered. And the second, the partners suing should be named as partners of the firm. Right? Partners suing should be named as partners of the firm. So these are the two things that should be there. What is this? Partners suing should be named as partners. So in the records of the registrar, he will have his register. So there you should be named as a partner of the firm. That is what we mean by his name should be registered as a partner of the firm. Now, when we talk about dissolution of the firm, dissolution means the whole existence of the firm comes to an end. So tell me one thing. When I say dissolution, is dissolution of firm also dissolution of partnership? Is dissolution of firm also dissolution of partnership? Yes, because if the firm is dissolved, partnership will obviously dissolve. But tell me, is dissolution of partnership also dissolution of firm? Absolutely no. Absolutely no. Because when the partnership dissolves means the relation of the partners change. That happens when a partner comes in or a partner goes out, and firm may continue, right? Firm will continue. Now, dissolution of firm can take place without the order of the court, or it can take place with the order of the court. When it is without the order of the court, it can be by agreement. What is agreement? Consent of all. That is, all the partners agree that let's dissolve the firm. Happening of certain contingencies. My firm is formed for a period of time, the time is over. My firm is formed for a purpose, purpose is over. A partner is dead, a partner is insolvent. Except one, all are dead, or except one, all are insolvent. In these cases, I can still continue, but here the firm has to be dissolved. The firm has to be dissolved. And if it's a partnership at will, I can dissolve the firm by giving a notice, right? I can dissolve the firm by giving a notice with the order of the court. Here, the court may pass an order, the firm must be dissolved. When does the court pass an order? When an application is made. Okay, who can make an application? Who can make an application? It can be made by any other partner, or it can also be made by any third party. Any third party. Even a third party can go and apply that please dissolve the firm, right? When will the court order for the dissolution of the firm? Permanent incapacity of an active partner, not any partner, active partner. Sleeping partner court may or may not dissolve the firm, but active partner court will order for the dissolution. Perpetual losses. Firm is undergoing losses, no scope of turning it into a profit. Then a partner is consistently breaching the contract on and on, on and on. The other partners are telling him, don't do this, but he's constantly breaching the contract. Then the partnership has become an illegal association. Achha, illegal association means what? More than 50. Misconduct of a partner. Business becoming illegal. Okay, here, when I say business becoming illegal, you have one business that's illegal, firm band. You have 4 business, one is illegal. You can shut down that business and continue the rest. Except one, all are dead or all are insolvent. Ma'am, that too you told here, no. Except one, all are dead, all are insolvent. You should have dissolved the firm. But instead of dissolving the firm, you continue. In that case, what will happen? The firm will be dissolved, right? What will happen? The firm will be dissolved. I hope it's clear to all of you. Yes. So moving on to the next one. Just one second, guys. Now, what is the order of payment? Once the firm, remember the partners, once the firm is dissolved, remember the partners remain liable till public notice is not given. Partners remain liable till public notice is not given. Okay? That means, and if let's say I decide today to dissolve the firm, but we give notice after 20 days. And in this 20 days period, if a partner makes a contract in the name of the firm, obviously who is liable? The whole firm is liable. Now, in what order we pay? First, we pay outside liabilities, then partners advance, then partners capital. Then if there is any surplus, that will be utilized to pay off the what? To pay, the surplus will be distributed between the partners, right? So how will you write? You cannot just write the order of the payment. You just cannot write outside liability. The firm shall first pay off the any liability taken from any person or any liability it owes to any person outside the firm. Second, after the payment of outside liabilities, the partner's advance, that is any loan taken from the partner, shall be paid off. Then third, next line you will go, the any capital which has been contributed by a partner shall be paid off after the advance. Fourth, if any surplus is left, such surplus shall be distributed by the partners in their profit sharing ratio, right? Now, before I go into this, can I say the firm's property, including the partner's capital, shall be utilized to first pay off the firm's debts, right? Correct or not? Yes. It will be utilized first to pay off the firm's debts. Any surplus remaining after such payment, right, shall be distributed in the profit sharing ratio. Shall be distributed in the profit sharing ratio, right? But the concept is that I should get back what I bought in. So if my firm's assets is less than up to the what? Outside liability and the capital, right? 1, 2, 3. Then in that case, it is considered as if my assets are less, not enough to pay this, then it is considered as a deficit. And in case of deficit, the partners will contribute to the deficit in their profit sharing ratio. Right? In their profit sharing ratio, they will contribute to the deficit. And if a partner has both personal and partnership debts, his personal property will be used first to pay his personal debts and then his partnership debts. Right? With this, we are done with Partnership Act. Keep studying, happy learning, and stay motivated. Thank you so much.